All right, thank you, Robert. Hello, everyone. I'm glad you can join us this Thursday evening. I hope everyone's week is going well, and I know we all can't wait for the holiday next week. But tonight we have a special webinar on estate planning, everything you need to know. And we have attorney Emily Colts, who some of you might remember from a previous webinar we had. We're so glad to have her with us tonight, and we are ready to soak up all the knowledge that she's going to give us tonight. So I'm going to pass it over to Emily right now. So the floor is yours, Emily.
Thank you. Good evening, everyone. My name is Emily Klotz. It's okay, everyone says Colts, but it's Klotz.
Oh, sorry.
It's okay. And I'm hoping that this is everything you need to know, but I'm sure that there's something that I've left out inadvertently, and I apologize ahead of time. We have a slideshow that we're going to work together on, and we're going to start now. Right? Okay. That's the second slide. Let's go to the first slide. So one of the questions that I get pretty regularly is whether or not someone actually needs an estate plan. Oh, I don't really need an estate plan. My kids know what I want, or everything's going to my husband, whatever it is. But everyone actually has an estate plan. If you don't do anything, the state decides where your assets go. But it would be better, in my opinion, and in many people's opinion, to be able to create your own estate plan. I'm going to explain later what intestacy is. Intestacy means dying without a will, and those assets that you're leaving may go to someone you didn't really want to. You don't talk to your brother any longer, but he ends up getting a third of your estate possibly. So really, estate planning would be a good idea. And there are two very popular tools. One are called wills, and the other is trusts. We're going to mostly go over wills, but I'm also going to be discussing trusts. Next slide. Okay, so there are mistakes that you can make. And I list here some of the biggest mistakes. You can do the do-it-yourself wills and trusts that you get on websites like LegalZoom and other websites. Lawyers love those. And the reason we love those is because they create so many problems that the lawyers end up getting huge fees. Very often those do-it-yourself wills are not executed properly, and as a result, they're invalid. I'm sorry, there's a spelling error. Number 2, it should be improper use of and failure to fund a trust. So you've gone to the trouble of creating the trust, but then you don't put the assets into the trust, therefore the trust fails. Not coordinating your retirement designations with your estate plan. You in an IRA or other retirement financial arrangements, usually you can name a beneficiary and it will fall outside of your estate. And I'm going to go over that again. But it's important to coordinate this with your estate, with your decisions about what you want to do with your estate. You can leave things to children under the age of 18 inadvertently, and that creates a whole series of problems. You can just trust people to, quote, do the right thing. I trust my sister to do the right thing by my kids. That's not always the best idea. Or I trust my kids to do the right thing for my husband. And lastly, I know this is going to sound strange, but owning your own life insurance. You can have life insurance under your name, but other people can own it. They don't have to pay for it, but they own it. And so it's easier to access when you pass away. Next slide. Okay, so with respect to do-it-yourself wills and trusts, When someone creates their own will, his or her own will, there are usually mistakes. And the executor, the person who you name to be in charge of your estate after you die, will have to prove to the surrogate's court, which is the court in which handles estates, not the Supreme Court, the surrogate court. The lawyer or the executor will have to prove that the will that you did yourself was executed with the required formalities. And there's a whole formality about executing wills. One of the questions we always ask is, are you over the age of 18? Because you have to be over 18 to create a will. And I've got a 91-year-old sitting there laughing, saying, no, I'm not. And that creates a problem. We all know that he or she is kidding, but it's still a problem. And if the will is not executed as required by law before at least 2 witnesses with the certain formalities, it's not going to be accepted. And the estate will be administered as if the person died without a will. And that's not maybe what you want. So sometimes a lawyer can persuade the judge to change some of the errors, but it usually costs a lot to do that. You know, anytime you go to court, it costs a lot. So do-it-yourself wills and trusts are not always the best idea. Oh, I skipped something. Sometimes you leave something to a child or someone who's getting government benefits like Medicaid, and because they've gotten a bequest, it kicks them off of Medicaid. So you want to, these kinds of do-it-yourselves wills do not protect against that usually. And that's something you may want to protect against. Okay, next slide. So if you die without a will or without a valid will, the estate will be settled based on New York state laws of intestacy. And some people come to me and say that intestacy, they think that means that the state gets the money. The state does not get the money, usually. The laws of intestacy outlines who inherits what. Next slide. So if the decedent has no children and leaves a spouse, even if you're separated from the spouse for, 20 years, the spouse gets everything. If the decedent leaves a spouse and 1 or more children, then the spouse gets the first $50,000 plus 1/2 if there's 1 child, or 1/3 depending if there are more children. So if it's so the 50,000 plus 1/2, 1/3 goes to the spouse, the living spouse, and the 1/3 is divided amongst, I'm sorry, the 2/3 are divided amongst the children, whether there's 2 children or 32 children. And if there are 32 children, God love them. And if the person who died had a child who died before that person, predeceased, but the predeceased child had children, those children would inherit that portion of the deceased child's share. That may not have been clear, so I'm going to use names. Joan passes away having a spouse and 2 live children and 1 deceased child named Joe. And Joe had 3 children when he died. Joe's 1/3 share of the amount that the children would inherit would be divided by Joe's 3 children. I hope I'm being clear about that. If I'm not, we'll go over it during the question part. Okay, next slide, please. Okay, so continuing on, if there is a child, if there's no spouse and there's a child or children, the child or children will share equally, including the predeceased child. And adopted children have the same inheritance rights as biological children. Stepchildren, you have a blended family and you have stepchildren, they are not entitled to receive anything from the non-biological parent estate. If there's no surviving spouse, if there's no children or grandchildren, the next in line would be living parents. Then if there are no living parents, the brothers and sisters of the deceased, the nieces and nephew, aunts and uncles, and finally first cousins. And it's in terms of closeness of blood, that's how this sort of tree of inheritance was developed. Okay, next slide, please. Okay, so one of the things you have to think about is whether, when you're making your estate plan, is whether you're part of a blended family. There are children from previous marriage, so you may want to provide for those children. You may want to provide for stepchildren in a will. If you have a disabled person who's part of your family and you want to leave that person money, if that disabled person is receiving government benefits, you don't want to leave anything that might put those government benefits in jeopardy. So there are ways to leave money to that person in your will so that they're not kicked off of Medicaid or SSD or SSI or Section 8 housing, that kind of thing. You can also, and we're going to talk about this a little bit later, transfer assets not using probate. Probate is the process by which you administer a will. So if you have, we're going to again talk about this later, if you have a joint account, like your checking account or your savings account, that automatically goes to the person who's on, or persons on the account, and it falls outside of probate, and the court does not at all, it doesn't involve itself in that. You also have to think about who you want to be in charge of your estate after your death. That person needs to have the time and the energy to be able to handle the workload. It's not a terrible workload, but you want to make sure that it's the right person. And if you have minor children, you can name in your will the person you would like to be the guardian of your minor children. And so that should also be a consideration when you're thinking about creating a will. Next slide, please. Okay, so in a will, you can identify what kind of property you leave and who should receive it. And some people come to me and say, you know, I did my will 10 years ago and I no longer have the account that I mentioned in the will. I don't actually recommend that you name a particular account. You could say what's in my checking account, or you could say all of my savings accounts. But you need to identify whether it's cash or you want to leave your grandmother's wristwatch to someone as a bequest. So you can, as they say in the next line, you can leave a bequest of specific property. I leave my father's pocket watch to my grandson who is named after my father. Or you can also leave a percentage of your estate. So people will come to me and they'll say, well, I have $100,000 now, but I don't know how much I'm going to have when I die. So instead of leaving an exact amount, we leave a percentage. I leave 50% to my husband, and I leave 10% to each of my children. In a will, you also have to name the person you're going to have administer your estate. That's called your executor. As I said, you can recommend a guardian for your minor children. The will, after you pass away, the executor is going to submit the will to court to be probated. And we are going to talk about probate. But if you don't want to have to put your family through probate, you can create assets put your assets into a trust. And the trust can end or continue after your death. And the trustee will manage all of the assets for the benefit of the people who will ultimately inherit the property. Those are called beneficiaries. The good part about a trust is that it avoids probate. The bad part is that it adds a level of complication and extra tax returns and things like that. But we'll talk about that when we get to the trust part. Most people do wills because it's simply easier and cheaper. Next slide, please. Okay. So in your will, you could, again, you appoint an executor. You can name a guardian for minor children, possibly also for disabled children. You can name a caretaker for your pets. If you have, a dog or a cat, when you die, who's going to take care of that animal? And you can also create in your will a trust. It's called a pet trust, leaving a little bit of money aside to pay for the cost of the care of the animal. And in the will also designates where your assets go after you pass away. Next slide, please. So there are various kinds of wills. Most wills that we talk about are called last wills and testaments, or wills. It's the same thing. And you designate, as I've mentioned, your final wishes about your estate assets like bank accounts, personal property, and who inherits. I want to put I didn't put this in the slide. Many people come to me and they say, in my will, I want to say where I want to be buried or what I want as my final wake or whatever. You don't put that in the will. The will isn't usually opened and probated for possibly weeks, possibly months after you pass away, and your burial will probably have already taken place. Okay, there's another kind of will called a pour-over will. It's just like a last will and testament, but if someone has already established a trust, that person should also have a will in case any of the person's assets have not been mentioned or transferred into the trust. It pours those assets over into the trust that was previously created. There's something called an oral will, and it's only valid. People say, oh, he told me what he wanted. Well, a valid oral will is only possible if you're a member of the armed forces, while you're in actual military service, during a war or other armed conflict. There's also called a handwritten will. People ask me that all the time about handwritten wills. It's just like an oral will. It's only valid if made by a member of the armed forces while in actual military service, during war or other armed conflict, and must be written entirely in the testator's hand. So sometimes in the movies, you see someone in a war movie, you'll see someone say, take this down for me. This is what I want. My wife should get everything. That's not a valid will. Okay, next slide, please. You are not required to hire an attorney to prepare your will, but a lawyer can provide useful advice. Also, and we talked about this earlier, you have to have a very special way to execute or to sign the will. An attorney can supervise the proper execution of a will, and the court presumes that if an attorney supervised the will, it was properly executed, and you don't have to prove a lot of the things that would have to be proven if the attorney doesn't supervise the will. And if you're going to an attorney to prepare your will, you should also consider other documents, and they can all be done at the same time. Do a power of attorney, a healthcare proxy, and there's a form called disposition of remains. That in that form, you can name a person to dispose or to deal with your remains after you pass away. I'm actually just had a situation this morning involving a man who has no relatives, blood relatives. There is no one authorized to handle his remains. He died yesterday. His body is in the morgue. He has family who know his friends who know what he wanted in terms of a funeral, and he wanted to be buried next to his wife and all of that stuff, but there's no one who can sign the forms needed to get him buried. And that's a real problem. So had he executed this disposition of remains forms, he could have named an agent to handle all of this for him. The other way to deal with that is to pre-arrange your funeral. You can pre-arrange a funeral. Honestly, I love my children. I don't trust them to do what I want for my funeral. I've already prepaid or started, I'm doing it in parts, prepaying my funeral so that when the time comes, they don't have to make decisions. It's already decided for them. And they just have to call the funeral home and everything will be taken care of. I think I'm doing the right thing for them. Not everybody may agree, but it's something you need to think about. Some people say to me, I don't know where I'm going to be buried, maybe here, maybe Florida. You give the money to the funeral parlor to pay for your funeral. It's held in a trust, earning interest. And if in fact you then move to a different state, that trust account that is being held by the funeral home can be transferred to a different state or to a different funeral home. So that shouldn't be your concern just yet. Okay, next slide, please. Okay, there are two questions that I'm gonna deal with now. One is, how do you prepay for a funeral and is it safe? So you prepay for a funeral by going to a funeral home, picking out, making your choices, and some funeral homes will actually let you pay over time. It is safe. The money has to go into a special fund managed by the, I don't know whether it's the state or a group of funeral homes, but it's in an escrow account, so that's fine. With regard, there's another question.
What we can do is actually
proxy.
Have these questions collated, and we'll present them towards the end.
Okay, I'm sorry.
So
I just didn't want to leave. I didn't want to leave anyone confused in the dust, as it were. Okay. All right. So who should be named as executor? That's like a big decision. Once you've decided where you want your assets to go, I want my grandfather's watch to go to my son. I want my bank account to go to my daughter. I want my apartment to go to my husband and my disabled child. Whatever you've decided, then you have to decide who's going to handle the estate. That's the executor. It could be your spouse. It could be an adult child. It could be a friend, a relative. And you can also name more than one person, but make sure they work together. And I'm going to give you a war story. I had an estate where there were 3 named executors, none of whom spoke to each other. They couldn't stand each other. And the person who died was hoping that making these 3 people have to work together would help them in making them talk to each other. Instead, they spent almost the entire estate on legal fees arguing over who should get the used sheets and who should get the broken Christmas ornaments. And if you think I'm kidding, I'm not. It was ridiculous. So please make sure that they can work together. And finally, you can name an executor or an attorney as an executor or a joint executor. In the old days, attorneys used to say, oh, you should name me, because they knew they were going to get paid. An executor gets paid a percentage of the estate for doing the work. But that's now discouraged. But you can name an attorney if you have no one else to name, or you just trust your attorney. Next slide, please. Okay, so this explains will requirements. I'm sorry about the small print. So in order to sign a will, you have to be 18 or older. When signing the will, the person signing, named a testator, cannot be under the influence of drugs or alcohol, which would impair the person's understanding of what he or she was signing. Can you take your medicine for diabetes? Yes. Can you take, 6 extra doses of oxycodone? No. Can you drink, a bottle of wine before you go in? I wouldn't let you sign. Even if you seem sober, I wouldn't let you sign. So when the person signs the will, it should be done in the presence of at least 2 witnesses, or acknowledge to the witnesses. Pre-sign it. You can pre-sign it, but you can say to the witnesses, this is my signature. The better practice is to sign in the presence of the witnesses. You can have more than 2 witnesses, but not that many more, because it gets a little onerous, difficult. But you can have, at least 2 witnesses, and then the witnesses must swear that the testators signed in their presence or acknowledged his signature within 30 days of the person signing the will, and also at the testator's request. So basically, at a will execution, after I've asked the appropriate questions, are you over the age of 18? Do you understand the English language? Can you read and write the English language? And if you can't, there are questions and ways to deal with it for Spanish people or other languages. Then I have the witness sign in front of the witnesses. I'm sorry, I have the testator sign in front of the witnesses, and the testator says, this is my signature. I would like you to see my signing and also see that each other is signing. And then that's done before a notary. And the testator has to say, this is my last will and testament, because one of the questions that may be asked at the time that the probate occurs is, did the person signing the document know it was his or her will? Okay, and then a notary, the will doesn't have to be notarized. However, it's a better practice. You don't notarize the testator's signature, you notarize the witness's signature, and it's the better practice to do that. Okay, next slide, please. Okay. In order to execute a will, the person has to have what's called testamentary capacity. That person needs to, and it's the lowest standard of capacity. They have to understand what they're doing. It's sometimes referred to as having a sound mind. It doesn't mean that they have to be completely clear-headed. You only need to know that what you're signing is a will. You have to know basically how much property you have, where that property is going, and who his or her natural bounty is. And that's a term usually meaning family members. You don't have to leave the property to your natural bounty, but you have to know that you've got brothers and sisters. Even people with mental disabilities may make a will if they meet these requirements. Next slide, please. Okay. In a will, you usually can control who gets what. However, you're not allowed to disinherit your spouse. If there are no children, the spouse can elect what's called elect. It's called the right of election. The spouse can elect to receive 1/2 of the estate. If there are children, the spouse gets 1/3 of the estate, even if he or she was left nothing. All right. Now, it is possible, it usually happens in second marriages, that the spouse can waive the right of election. And if the spouse does that, I'm waiving my right of election, you can leave everything to your kids, for example. It has to be a statement prepared and signed and before a notary public. Okay. Next slide, please. I'm sorry. My computer is not charging. I have to get someone to help me. Hold on 1 minute.
Sure, and we'll just take this opportunity to encourage anyone those who are present, and there's quite a few of you, to post your questions.
Okay.
Do take advantage of our Q&A and any doubts and questions you have on this fantastic topic. And we do have a Spanish interpretation for those who would like to listen to
Okay, I'm back.
Spanish. Sure.
I'm very sorry. I've just called one of my sons to get my charger. Okay. So this is a little complicated, testamentary substitutes. Sometimes there are ways to do planning without including certain assets in the estate. There's a plug over there. So you can make a gift. You can make a gift in contemplation of death. So for example, I know I'm about to die. Here is my grandfather's watch. That's called a testamentary substitute. It's easily challenged, so it's not the best thing to do. You can also transfer property within a year before death. And that can be excluded from your estate. It can be so that it's not included in your estate for tax purposes. But if you transfer $1 million house for $1, that's not considered an appropriate gift. It's got to be the transfer of the property has to be, you have to have received adequate money for the gift or consideration. So if the consideration is the love and attention of my children, that usually works. There's also things called Totten trust accounts. The easier way to explain it is a joint account or in a trust for account. So you open a bank, you open a CD, for example, and you have, it's in your name, but it's POD, payable on death, to someone else, or it's held jointly with someone else. That falls outside of your estate and it goes directly to the person who's named on the account. Next slide, please. Okay. Joint bank accounts, whatever was deposited and not spent, together with any dividends and interest, is payable directly to the person on the joint account. All they have to do is show up with a death certificate. And I already mentioned the Totten trust. I don't know why it's there twice. So next slide, please. IRAs, 401ks, pensions, annuities, stock bonuses, all of that stuff can be excluded from your estate, although included for determining the amount payable to the surviving spouse under the right of election. So most of things like retirement accounts will ask if you have a named beneficiary you want to include. If you don't name a beneficiary, it goes into your estate. Any other property that's held jointly, for example, title to a home or an apartment, there may be something that says, a deed that says joint tenants with rights of survivorship, or tenants by the entirety, which is slightly different, or property held to joint tenants as husband and wife. That also falls outside of your estate. And there are certain securities that will be transferred automatically if you register them as transfer on death registration. Okay, next slide, please. Okay, so I tried to explain here what a joint account is, because there are two different kinds of joint accounts. Most accounts are held by two people or more, and they have the same right of access to the funds, and you don't have to get permission from the other party to make a transfer out of the account. Doesn't matter who puts the money into the account. And this is a good way to minimize your estate, or make sure that the person, it takes some time to administer an estate, and you can't access the money for at least 7 months. So a joint account allows someone to access the account as soon as they can get a hold of a death certificate, and they have working money. They have money to use until the estate is probated. It's also, a joint account can be used as, under common law, as proof of relationships for immigration or visa purposes. But sometimes there's something called a convenience account. Well, continuing on with a joint account, sometimes a mom will put a parent will put a child on the account so that the child can help the older person or an ill relative handle their rent and their other financial obligations. Okay, next slide, please. Okay, so if both parties die, there's a joint account and both parties are deceased, the heirs of the last survivor ends up with the account. So it wouldn't be split 50% to the one person and 50% to the other person's heirs. It goes to the last survivor. So husband and wife, husband dies first, wife dies 4 days later, the wife's estate controls. Now, there's something called a convenience account. It's one person's money, but it allows check writing for a child. It's titled as a joint account, but it is possible that other children may claim the account was not intended to be a survivorship situation, that it was only a convenience account that mom put her child on so that the checks can be written, and so there could be a contest about that account, and that's usually decided by surrogate's court. The joint accounts may have titles like WROS, which means with rights of survivorship, or some banks use JTWORS, joint tenants with rights of survivorship. Okay, next account, please. Slide, please. Okay, so now let's talk about the executor's responsibility. You've made a will, you've determined who the executor is going to be. What does that executor have to do? The executor has to petition the surrogate's court requesting the issuance of letters testamentary. What that means is they take the will, the original will, which, by the way, under no circumstances should you, once it's signed and stapled, do not take those staples out, because there's a presumption by the court, if the staples have been removed, that there has been, that it's not a valid will, that it was unstapled because people were putting in different pages, middle pages. In my office, we rivet it so that you can't unstaple it. Okay, so the executor has to take the original will, an original death certificate, and fill out a petition and submit it to surrogate's court. to ask for what are called letters testamentary. And the letters testamentary authorizes the executor to transfer any bank accounts into an estate account. An estate account is opened after the executor gets a tax ID number. It's like a social security number. And that is required by a bank before they'll open up a estate of Emily Klotz's account, for example. The executor is also responsible for clearing out the apartment or the home and distributing or disposing of the contents of the apartment. An executor can pay, if it's not already been paid, the executor would pay the funeral and other debts first, taxes, and then distributes the balance of the estate to the persons or charities named in the will. That distribution does not take place for 7 months after letters testamentary are issued, and it can take some time to get those letters issued. The executor receives a percentage of the estate for acting as the executor. It's a small percentage, and it depends on the size of the estate. Okay, next slide, please. How often does your will need to be updated? It's up to you. You may never need to update it. But I had one client, my hand to God, this is true. Every Tuesday she would call us. She wanted to change her will. It was all, she had no family and she was leaving things to charities. So every Tuesday, if we didn't hear from her by Wednesday, we were worried that she was dead. We would reach out to her. So the only version of the will that matters is the one that is most current. So if you've done a will and then 10 years later you do another will, that the most current will is the one that controls. However, if that will is declared invalid because you didn't execute it properly or there were problems with the will, then the court may decide to use the prior will. But it is a good idea to review and possibly revise your will whenever there's a major change. You get married, you get divorced, you have a grandchild, one of the beneficiaries died, you won the lottery, and now you've got all this money that you want to distribute in a different way. Those kinds of things. During those events, you should consider redoing your will. Next slide, please. Okay, where should you keep your will? Do not keep it in a safe deposit box in a bank that your name is on, because if you die and the bank finds out about it, the person who's named, there may be a person who has co-title to the bank deposit box. But once you're gone and the bank finds out, they cannot access that box. So you should keep it in a safe place. You can file it with the surrogate's court. It costs $45. And every time you update it, you have to file it again. So that becomes expensive. So I would say that, you can have a waterproof and fireproof safe or box in your house. You can buy them at Staples. You can buy them at Costco or Sam's Club. And my office and many other offices offer a service that we keep the will in a safe deposit box maintained by our office for our clients. And when the time comes, the family calls us and says, so-and-so died, our mom died, now we need the will. And it's, within 24 hours, I can access that bank box. You should tell your executor where you're keeping the original will, because only original wills are accepted by the court, except under certain rare circumstances. You can give the will to your executor, but the executor, again, has to keep it in a safe place. Okay, next slide, please. Okay, so probating the will. I sort of jumped ahead and discussed this a little bit. When the testator dies, the proposed executor prepares a petition. The surrogate's court in New York State has a website with the forms. You do not have to get an attorney to probate a will. You go onto the New York State Surrogate Court website, and they have the petition already there so that the executor can fill it out, him or herself. The court will review the petition, the will, and there are certain other documents that are required. Very often the court will want a family tree or an affidavit from a family member or a friend, not a family member, I'm sorry, a friend saying, I knew this person for 40 years. She was married. Her husband passed away. She was never remarried. She had 2 children, and these are the names of the 2 children. Also, the court will require that distributees, that's a special word that I'll explain, of the person who passed away be notified that the will is being probated, whether or not they're named in the will. So for example, a distributee, let me start it by explaining that. A distributee is a person who would inherit if there were no will. So for example, you haven't talked to your brother in forever, and you're not leaving him anything, and you don't really like him, and you don't want anybody to talk to him, but the named executor will have to advise him that you've passed away and that you have a will, and the named executor will give him a copy of the will, and this will allow that person, your estranged brother, to challenge the will. Okay, next slide, please. Okay. If an estate is $50,000 or less, the surrogate's court doesn't want you to get an attorney. And $50,000 to me is a lot of money, but to the surrogate's court, they call it a small estate. And whoever remains can make the application, just simply filling out these forms that the surrogate's court has on their website. If the estate is $50,000 or more, let me back up. The reason the surrogate's court doesn't want you to retain an attorney is because they don't want the attorney's fees eating up the estate. If the estate is $50,000 or more, you can prepare and submit all the required documents yourself. Again, they're online. In the old days, pre-pandemic, you could go to the courthouse and there would be someone there to assist you. But now you have to make an appointment, and it's not so easy to do that. But your family, the people who are left, may find it too time consuming or too burdensome or too confusing to complete the required documents. Okay. Next, there's something at the bottom of that slide that I can't read, and I don't remember what I included. Okay. All right. So in a will, you specify what happens with your, in a will, you specify what happens to your debts and those of your loved ones. So outstanding debts are as part of the distribute. Before anything can be distributed to your beneficiaries, any credit card debts, etc., any loans have to be settled. That does not include a mortgage. And if you owed a loan or debt at the time of your death, your family may end up having to pay for it, depending on the estate, the value, and the type of loan, especially if someone co-signed on the loan. So if you have a joint account that passes to a surviving owner that's not part of the estate, it cannot be used by creditors to pay off, to be used to pay off the creditors, except if it's a convenience account. The one exception is if the surviving joint owner, let's say husband and wife, was also a signatory to the loan, that surviving owner will be held liable for the remaining debt that can't be paid off from the estate. So for example, husband and wife takes out a loan to pay for the child's college education, and you both sign on it. Whoever passes first, the remaining signatory will still be on the hook for that debt. Okay. I hope that was clear. Next slide, please. Okay. The executor has to first, or the administrator, because a lot of this is the same as if it's an administrator, has to inform the credit card company or the institution that has the debt, or if it's a personal loan, has to advise that person that the debtor is passed away, and the creditors have to make a claim against the estate. The creditors also, if asked, and only if asked, have to prove that it's a valid debt. So sometimes you get these scam artists who say, oh, she owed me $10,000. You want to make sure the executor is responsible to make sure what that's a valid debt, and they have to ask for copies of the loan agreement and copies of any payments made to the decedent. The creditors are paid first. So if there's not enough money to cover, if there's enough money to cover the debts, or even not enough money to cover the debts, the beneficiaries may not receive any money. And secured creditors are paid before unsecured creditors. So attorneys and the funeral home and the IRS and Medicaid, for example, has priority over other unsecured creditors. Attorneys not being foolish and always wanting to get paid, right? Okay, next slide, please. All right, so after all of the assets have been gathered into the estate account, and something that people forget is to look on the New York State Comptroller's unclaimed fund site for possible assets. And all the debts have been confirmed, and all the debts have been paid, and 7 months have passed since the issuance of the letters of testamentary or the letters of administration, you can start distributing the assets. The executor should provide to the beneficiaries an explanation of how the estate was handled. I paid rent for 2 months until I cleaned out the apartment. I paid off these credit cards. Mom had started with $100,000. I paid off $25,000 in debts and other expenses. I paid the funeral. And now what we have left is $75,000. You're each to get a third. And so you each get $25,000. Before any distribution is made, the executor should get releases from the beneficiaries so that there's no future challenge to the distribution. And you have to get releases from all the beneficiaries before any distribution is made. Okay, next slide, please. Okay, so it's possible for there to be a will contest. For example, a child who would have inherited more if there had been, sorry for the spelling error, if there had been no will, or a wife who believes that that her husband created a will under conditions of undue influence, or there are other ways of contesting a will. They're not easy and they're very expensive to do. So in the first example, a parent had a spouse and 2 children, but one child got 10% and everyone else got 90%. The child would have received more of the estate if no will existed. That child may decide to contest the will. I had a case where there was only one surviving child, but she was estranged from her mother, and her mother left everything to neighbors. The child contested the will. It was ultimately settled. The child got 10% or 15% of the estate. But the mother didn't want her to get anything because the mother really didn't get along with the child. And the undue influence category, and that's a very broad category of challenge. It could be that the testator felt that he had no choice but to leave money to someone that he didn't really want to leave it to, or omit someone from a will that he didn't really want to omit. And the person challenging the will would have to prove that there was undue influence. Okay, next slide, please. We sort of talked about this earlier, that the proponent of the will, usually the executor, the named who is the person as the executor, and who files the will with the court, and you file it where the person died, the county where the person died, usually. It's usually the same place as where the person resided. The petitioner has a burden to prove it's a valid will, but if the will was executed, if the will execution was supervised by an attorney, the law presumes proper execution of the will. Next slide, please. Okay, and again, contesting a will. It's a way to try and invalidate the will. Only a beneficiary or a distributee, that would be a person who would inherit if there were no will, can contest the will. So if you're a neighbor and your neighbor always said to you, oh, I'm going to leave you my all of my money, but that's not what the will says. Since you're not a beneficiary of the will and you're not a distributee, you don't have the right to contest the will, no matter what your neighbor promised you. Except, the one exception is if you believe that there was fraud involved or forgery, that wasn't that person's signature at the bottom of the will. You cannot contest a will just because you don't like the provisions or feel that you were not treated fairly. Meaning, I thought I should get 50% and I'm only getting 10%. That's not a basis for contesting the will. You would have to say it was because of undue influence that I'm only getting 10%, or because the person didn't have mental capacity that I'm only getting 10%. So after a will, if a will is successfully contested, the court invalidates the entire will, but may sometimes instead just invalidate a single provision. But the rule of thumb is the entire will is invalidated. The court may admit an earlier will or may not admit any will and then distribute the estate following the laws of intestacy. And will contests can be very expensive and consume a large amount of time and money. Okay, next slide, please. So one of the bases, some of the bases for contesting a will is lack of testamentary capacity. That means that the person did not understand what they were signing at the time. Even a person with dementia or with developmental disabilities can sign a will if he or she was lucid at the moment of signing. The ink doesn't have to be dry, and the person can forget what he signed, but if at the moment that ink touched the paper, that person knew what he or she was doing, that's sufficient testamentary capacity. In fact, I've been involved in guardianship cases where the court has determined a person needs a guardian, and yet will say, but make sure that he does a will. Make sure that the person I just declared incapacitated also completes a will. So the person contesting the will under lack of capacity has to prove that the testator didn't know or understand what she was doing, how much she owned, who her family was, what the terms of the will were. Because of cognitive impairment, such as dementia, mental illness, mind-altering medications, and other things. And one way of going about doing this is obtaining the testator's medical records, but you need a court order to do that. Okay, next slide, please. Lack of validity. You can claim that the testator didn't follow the proper protocols. In other words, that's usually meaning that it wasn't executed properly. This is not, this basis rarely wins, particularly if the execution was supervised by an attorney. Next
Oh.
slide, please.
Okay.
Okay, the slide's stuck. So there are other reasons. Next slide.
Yep.
Okay, good. So other reasons, and well, other reasons are duress, which we sort of talked about, and there are other reasons which we can go back to. So if you die without a will, the person in charge is called an administrator. And it's basically the same process that an administrator goes through that an executor goes through. The law will decide who the administrator will be, and it's usually a family. It's almost always, it has to be a family member. And the administrator has to confirm the family tree. In the event that you cannot find someone to administer the estate, I did not include a slide on this, but I'm going to tell you this, that there is every county in New York State has an office of public administrator, and that office of public administrator is the organization that the state has determined should handle estates where there is no one authorized to act as an administrator or an executor. You can name an executor, but the executor cannot have been convicted of a crime. So if the executor you name after you've named him ended up going into jail because of a crime, that's no longer a valid executor, and the public administrator, another family member can apply, or the public administrator would handle the estate. Once letters are letters of administration, these are called letters of administration, not letters testamentary. The administrator has to contact the banks and transfer the agent, get a tax ID number, everything we talked about already with regard to what an executor does, dispose of the apartment and any non-valuable personal property, contact creditors and stuff like that. Okay, next slide, please. Some wills have what are called no contest clauses, and many states do not allow for a no contest clause. If someone's going to step forward to contest a will, then a no contest clause will specify that whoever is contesting will be cut out of the will altogether if he or she contests the will. They may seem unfair because it's like an all or nothing scenario. So son Joseph says, it's not fair, I'm only getting 10%. I'm going to contest this will. But the will has a no contest clause that says if anyone contests the provisions of this will, then they get nothing. That's what a no contest clause is. So it would not benefit Joseph to contest the will if he loses, because he's not going to get anything. In New York, these clauses are valid. And it does not matter if the beneficiary has a cause of action to contest the will. It can still take effect and disinherit the contester, unless the contesting individual can say that the will is being offered in the wrong county and is not challenging the contents of the will or contesting the person's competence. Okay, next slide, please. So that's pretty much it for wills. Now, a trust, you can create a trust in your will, and there are various kinds of trusts which we're going to go over. So a trust provides for the distribution and management of your assets while you're alive and after your death. And a trust can have any asset that you hold inside the trust. It could be your car, it could be your apartment, it could be your grandfather's pocket watch, it could be, it's usually an apartment, real property, and bank accounts. It can offer you more control over when and how your assets are distributed. And it can be, as I said, in a will or not in a will. The creator of the trust is called the grantor. And that person must fund the trust by legally transferring the assets into the trust. So for example, if you have an apartment that you're putting in the trust, you have to create a new deed. or shares of stock. They have to be put into the trust. There are a lot of co-ops that don't allow for the shares of stock to be held in a trust, so that creates a problem. If you have a car, you have to retitle the car, re-register the car into the name of the trust. If you have a bank account, the bank account has to reflect in its title that it's part of the trust. Personal items such as, let's say, a stamp collection that you want to put into the trust, that's more difficult because you can't actually prove that you've transferred it over. But if you insure that piece of property, that stamp collection, for example, and you have a homeowner's insurance that insures that stamp collection, it should be the proceeds of any insurance policy would be paid to the trust and not to an individual. Okay, next question, next slide, please. So there's something called a testamentary trust, which is the trust in the will, and it would allow, usually these kinds of trusts are for either minors I say minors, but I create trusts that last as long as to the age of 30 and beyond, because you don't necessarily want an 18-year-old to get all your money, because they'll use it for something foolish. Possibly, it depends on the 18-year-old. So you may want to, in your trust, in the testamentary trust, the trust in your will, say, so my son could get money at the age of 21, or when he graduates from college, and then he gets 25% when he gets married, or at the age of 25, whichever comes first, and then gets the rest of it at the age of 30. Or when he has a child, whichever comes first, just as an example. You can also create in your will a pet trust, or it can be outside of your will, a pet trust to fund the care for any pet that you may have and that you're leaving behind. Next slide, please. Then if you're going to do a trust outside your will while you're still alive, there are a couple of different types. There's one called a revocable living trust. That means that you can act as your own trustee, handling how the assets are managed during your lifetime. And you can also undo the trust. That's called revoking the trust, or change the terms of the trust, or move property in or out of the trust. Usually this kind of a trust switches over to become irrevocable, non-changeable upon the death of the grantor. Okay, next slide, please. Then there's something called an irrevocable trust. It becomes legally binding on the date it's signed and when the assets are transferred into the trust. Not just signing, but the assets have to be transferred into the trust. It's very difficult to change. It's usually used for Medicaid or other government benefits to protect the funds from Medicaid and other government, and qualify for Medicaid and other government benefits. It's no longer under the control of the person who funds it. You have to name a third party to be the trustee. It's someone you should be someone that you work with well. And the benefits to an irrevocable trust, the benefits to an irrevocable trust include Medicaid planning, protecting the grantor's home, and savings from long-term cost of care. And these benefits may make it worth giving up control of your assets. But if you like control, an irrevocable trust is not for you. Next slide, please. How to choose a trustee. Well, the trustee is a fiduciary. That's a fancy name for the person who's in charge of finances. And that person has to be impartial about their own interests and put the beneficiary's interests first. So the fiduciary may not like your son, but has to be fair to your son. You have to make sure that that person, that trustee, will be fair to all parties, will be comfortable hiring an attorney or an accountant if needed, can manage your finances appropriately. Will that trustee be tempted to take any money out of the trust to pay him or herself at the expense of the beneficiary? Will the person have time to act as the trustee? And if you name a child, will that child to be fair to be other siblings, even if they're step siblings and they're beneficiaries of the trust? Okay, next slide, please. Okay, so assets that can be transferred into the trust include stocks, bonds, money markets, copyrights, house or other real estate, jewelry, works of art, stamp collections, etc. Usually you can put a life insurance policy into a trust, but it's not always necessary. It's not necessary to put, and it would not be appropriate to put payable on death accounts into a trust. Jointly owned accounts or jointly owned assets do not go into a trust. And real estate that is subject to transfer on death, like deed, it shouldn't say dead, it should say deed, that, for example, a husband and wife with rights of survivorship, that property doesn't go into a trust. That property falls outside of the trust. Okay, next slide, please. All right, so what happens is, and it's happened on more than one occasion that I know of, people will sign the trust and never move the assets into the trust. So the end of a trust usually has a Schedule A, and Schedule A lists all of the accounts that should be in the trust. And then, but just listing it is not enough. They actually have to be transferred. So the real estate the new deed has to be done. The name of the bank accounts have to be transferred. And property not transferred into the trust is subject to probate. Okay, next slide, please. I think we're done. Okay.
I believe so.
So I apologize for the spelling errors. I don't have spell check on PowerPoint, and I sincerely apologize. I see there are a couple of questions.
We have several questions and we can dive right into them, and I'm sure that there will be others as we move along. The very first one, I believe, what is the difference between a living will and a last will?
Okay, so a living will is a document that I think I discussed the last time I did a Palante thing. A living will is not a will. It's a document directing doctors and other medical professionals as to what you want for your last, for your medical treatment. It is a document that is not it's not a statutory, it's not recognized by the court, but it's usually followed by doctors. And in it you say, I want nutrition and hydration. I want pain. I want pain medications. I don't want to be on a ventilator. I do want to be on a ventilator. And my child, Susan, knows what I want. You can only name one agent at a time. That's a living will. It's only effective while you're alive, because obviously you don't get medical treatment after you pass away. Although in a living will, you can say that you want your organs donated. A last will and testament only takes effect once you're gone. I hope that's clear.
For power of attorney, healthcare proxy, is an attorney needed?
No, an attorney is not needed for any of those documents, although a power of attorney form will say on the front, this is an important document. There's a cautionary, it's almost a full page, cautionary page that says, this is an important document conveying a lot of important rights, so you may want to consult an attorney. They're not necessary. Certainly a healthcare proxy does not require an attorney. It requires 2 witnesses.
What do you charge to prepare a simple will? What documents, information do you require to prepare the will?
Okay, so normally it's not appropriate for me to discuss fees, but I will tell you that depending on the simple will, it can range from $200 or $300. If there's trust involved, it becomes more expensive. Powers of attorney healthcare proxies. These should not be expensive documents unless you're creating a trust, and the trust can be $2,000-$3,000 or more, depending on the complications of the trust. Usually not more than two. I'm sorry, I don't remember the rest of the question. Could you say it again?
The
What
question,
you need.
the information required
Right.
to prepare.
So I don't need any information, although a family tree is helpful. I just need, when I prepare someone's will, I simply ask them what they want. We can discuss how you want to leave it. I presume that someone knows their assets, and assets change over time, as I mentioned. So this should be a relatively inexpensive process, because lawyers want to encourage people to create a trust. Not a trust, a will. I should also say, and I did mention this, that usually in a will situation, whoever is the executor does not have to obtain what's called a bond to ensure that he's done the right thing. Usually in the will, you say, I waive the requirements of a bond. In an administration, a bond is almost always required unless the estate is under $50,000. And a bond is a few $1,000s and has to be paid for until the estate is distributed. So that's another reason to get a will. I'm sorry, I forgot to mention that. So what's the next question?
Sure.
I see one that's asked about.
Si un papá falleció y tenía una cuenta de banco y uno de los hermanos es beneficiario, ¿él tiene que compartir el dinero con los demás hermanos?
Absolutely not. And that becomes his, and it falls outside of the estate.
Are you able to prepare in a pandemic? Are you able to prepare the will via text or email? And how does one reach you?
Okay, so the way I've done it, and other attorneys I know are doing it, is we either by email or Zoom or just a phone call, we talk to the person about what they want, what would be appropriate for them, give them the same counseling I would do in person, and then exchange drafts until all the spelling is correct and all the provisions are correct. And then I personally, I meet with clients at this point. We'll socially distance, and I'll meet with clients, and I execute wills either in their home with witnesses or in my office with witnesses.
Does the lawyer take a percentage of the will when in charge, or is it a fixed amount? Is that written in the will as well? How much is it on average?
Okay, so I'm going to get the gist of this question.
Yeah.
The lawyer gets paid to do the will, if you've retained a lawyer to do it. If you've retained an attorney to handle the estate, some lawyers charge a percentage of the estate. It's my recollection, and I don't have the law in front of me, but my recollection is that the courts say you can't take more than 6% of the estate as your fee, or they get a flat fee hourly basis. If it's a small estate, it's certainly, there should be some consideration of the size of the estate. The lawyer doesn't get a percentage. The executor gets a percentage. And the executor's and the executor can waive any commission that the executor gets. It's considered income, whereas what you inherit is not income. You don't pay any income tax on that. You may pay estate tax if it's over $11 million, but I don't deal with many people who have that much money. So the executor gets a percentage, and it's based on, the rule of thumb is 5% of the gross estate, excluding real estate, for the first $100,000 that comes in and goes out, 4% of the next $200,000, 3% of the next $700,000, and then it goes down from there after you hit $1 million in your estate. I hope that answered the question.
If there's more debt than assets, what happens with the debt left over?
The secured creditors get whatever, as much as is available, and unsecured creditors, if there's not enough to meet those credit card debts, for example, they just lose out. If there's enough to cover the secured creditors and some money left for the unsecured creditors, let's say there's 100,000, I'm very bad at math, so let's do things in round numbers. There's $100,000 in debt and there's $10,000 left of assets, and there are 10 creditors, it's divided up 10 ways. Unsecured creditors, it's divided up 10 ways.
Is it a good idea to write a will even if no assets or property? Is assigning a beneficiary on an account sufficient or okay?
Okay, so one way of getting around wills is to just name a beneficiary on all of your accounts. Could be different beneficiaries on different accounts. However, I'm here to tell you that there's always something that you forget. There's the contents of your apartment. There is, there's maybe you have a car and, you don't even think about that. So it's like belts and suspenders. It's good to have a will just in case there's something that needs to be attended to. And it doesn't cost that much, but you can certainly get away without a will if you have all of your assets named, have named beneficiaries to them.
So I guess it's a good idea to periodically catalog one's assets.
Yes, it's also a good idea, if I may, to tell the executor where your assets are or leave some kind of instructions. I have accounts at Citibank and an Amalgamated, and I have a brokerage account at Franklin Templeton, so that the executor or the administrator has some idea of where to start. Otherwise, they're going to have to contact the IRS to find out where interest may have been reported. And maybe you've got a stock or something that's not generating interest, and then nobody knows about it. So you should have some kind of a document, and I can provide that to Palante, a sample document as to where I keep the deed to my cemetery, where I keep the my health insurance policy in case there's some kind of a benefit, or my life insurance policy. And these are all of my bank accounts.
How much is the percentage that the administrator usually gets paid? And if it's a public administrator, is that percentage paid to the government?
The public administrator hires private attorneys to handle the estates for them. They usually have one or two authorized. It has to be authorized. And the public administrator gets the same amount as a regular administrator or an executor, which is, as I said, 5% of the first $100,000, 4% of the next $200,000, 3% of the next $700,000, etc. But in addition, their attorneys get paid, and they get paid a lot of money. So it can easily wipe out or significantly diminish the value of the estate.
Can you explain what has to be done if you are a shareholder and you want to leave your apartment to your daughter, child?
Okay, so that is a little more complicated. If you're a shareholder in a co-op, you first have to find out if the co-op will allow you to transfer the asset. Very often the co-op will not allow you to transfer the asset. What you can do in your will is say, I would like my son or daughter, let's say daughter, to inherit this apartment. However, the co-op has the right to interview, just like a new tenant, new shareholder, potential shareholder who's buying into the co-op. They have to go through a financial background check, and a person. Some co-ops require a personal interview, etc. So if you leave the shares in your will to your daughter or into a trust for your daughter, upon your demise, the co-op has the right to demand that those shares are sold and that apartment is sold, and then whoever you leave the co-op to inherits the money that you get from the sale. But it depends on the co-op. Some co-ops understand the use of trusts as a protection device for Medicaid purposes, and they allow the transfer into a trust. Some don't.
Right.
So
yeah.
I see a question about what happens if the funeral home goes out of business.
That's right. That was a little further down. We can hit that one. What happens if funeral home,
Okay.
if the funeral home goes out or prepaid funeral expenses goes out of business?
Okay, so that the prepayment goes into an escrow account, not run by the funeral home, but run by, I believe, by the state. But it's not an individual funeral home. So that money is protected, and if the funeral home goes out of business, you can contact, and once a year you should be getting a statement as to what your interest is, the interest that accrued from this escrow account, and you contact that in that agency. And if you have questions about that, I'm happy to help you contact that person, that agency.
Is it, this question was asked before regarding beneficiaries, regarding instead of having a will, those designated as beneficiaries of a 401k or insurance policy, does their payout circumvent the distribution details of a will or fall outside the estate?
Absolutely. It falls outside of the estate and is not controlled by a will.
Can the same person be a trustee, an executor, a proxy, a power of attorney, an administrator, all of these things if specified as such by the decedent?
Usually they are, because there's usually one person that you trust over others. So yes. And you can have joint people doing this, except in a healthcare proxy. And a healthcare proxy and a living will, because the doctors don't want to deal with groups. One person has to be designated at a time, but you can designate a successor or a substitute. So yes, you can name the same person in charge of everything. And that's very common.
Why would you need a pet trust if you have a will that specifies what to do for the pet?
The pet trust is specifically for you leave money to support the pet. So if the will says my cat Cinnamon is to go to Emily, actually have that scenario, that's fine. But if you want to leave money to support the animals' food and care and vet bills, you can create a little pet trust and say, I'm leaving $10,000 for the care and support of my pet.
Is the percentage of successfully contested wills very low?
Pretty much. It's very difficult to contest a properly executed will.
Does the executor need releases from beneficiaries if there is harmony?
Yes, because there may be harmony now, but there may not be harmony in the future. And for example, in every release I've ever seen, there's also a situation, there includes a paragraph that says, if the IRS comes knocking on my door, this is an unofficial way of saying it, and the estate owes any taxes, you have to pay back a percentage of what you've inherited to pay off the taxes. So you need that executor needs that kind of protection.
But a beneficiary, I guess a follow-up to that could be a beneficiary does not have, can refuse to sign a release?
Yes, but then everybody refused. Then no one can get the assets. Because if one beneficiary is contesting what's going on, and that's the other way to process a will contest. If the will has been accepted, but you don't like the way it's been handled, the estate is handled, you can contest the handling of the estate. And one way of doing that is refusing to sign a release and going to court and saying, I think the executor should not have, I don't know, invested in this tech company, and I think he wasted the assets, and so I'm not accepting this. Or I don't want a distribution of cash. I want a distribution of the stocks in the value up to the value of what I'm inheriting.
But a signing of, but a distribution of assets in accordance with a will would not be contingent on beneficiaries signing the release.
Well, it is, because 4 people are to inherit. 3 people accept how it's been processed, and 1 person doesn't. That 1 person can hold up the entire estate until his objections to how the estate is handled have been resolved.
If people have these documents, they prepared these documents, but they're not readily available, is there a period after which the estate, the estate just goes into, is executed, for lack of a better word, is sort of in a default fashion? The documents are not found.
No, I've recently filed a will that was for the decedent died 4 years earlier, and no one bothered to probate the estate. But now they said, oh, we don't have to probate the estate. Everything goes to dad. But now they found that there's a particular issue and they require probate. So no, there's no deadline.
I guess my thinking in relation to that question is, can the court system determine what happens, and then a will is discovered that contradicts some of the measures taken?
Well, that happens, and that's a long and complicated process. That's really way too long for this. I mean, if a will is found 10 years later, the court's going to want to know why it took 10 years to find the will.
How do you get over the difficulty of having these types of conversations about these issues with the relatives or parents or in preparation?
That's hard. That's very hard. And that depends on family dynamics. You need to have these conversations. You need to have conversations about end of life choices as well. And they're very hard. You need to call everybody together, whether by Zoom or in person, if you're meeting in person, and saying, you know, I'm getting older, or mom is getting older, or whoever's getting older. It's usually to deal with age. And we need to talk about what I want for my end of life decisions and what I want for my funeral, etc. And I'm not treating everybody fairly under the will because cousin David is disabled and he's gotten medical malpractice award, and so he's taken care of. So I'm not going to take care of him under my will, but I'm taking care of other people. Or I'm not talking to your sister anymore, and so that person is not going to be included in the will. You just have to sit down and bite the bullet and do it. It's a very hard conversation to have, but it should be done all together if everyone's talking to each other, because you don't want one person hearing one thing and one person hearing something else.
How about using internet services like Legal Shield, Legal Zoom to create wills, and are they as binding as traditional attorney?
Well, I love LegalZoom, and the reason I love LegalZoom is because virtually none of their wills hold up, and so I end up making twice. I mean, I charge very little for a will, but to try and prove this will costs a fortune. So lawyers love LegalZoom for exactly that reason. And it's usually because the wills are not, they don't give you appropriate instructions to execute the will properly. Or if they do give you the instructions, they're not followed. So please get LegalZoom because it's going to help pay my mortgage. That's not, it's not that their documents are insufficient. It's that they don't always hold up for various reasons.
I think we're down to about 2 more here. Just a quick one. So are revocable, irrevocable, or revocable trust one preferable to the other?
It depends on the purpose of the trust. If you want to continue to control your assets, and you're creating the trust to avoid having to probate your estate, that's great. If your purpose is is that you're afraid you're going to go into a nursing home and you want to qualify for Medicaid or other government benefits, then an irrevocable trust is the way to go. But you may not have anyone you trust to handle your assets, because in an irrevocable trust, you can't manage your own assets. And that's a problem. A lot of people don't want to give up that control. So there's no, I can't say one is preferable over the other. It depends on the situation. And for those, really do not use LegalZoom or any of those internet services for a trust. They're way too complicated. And that's really where I would draw the line.
And so these documents, I think this is our final documents, like power of attorneys and disposition of remains and healthcare proxies. Trusts have additional expense, wills, and one should have ideally all of these types of documents prepared.
Yes.
The question.
Yes, it doesn't take long unless you're not really sure what you want to do. But I usually get these prepared in one phone call or 2 phone calls and an in-person meeting, as long as you know what you want. Sometimes you need to talk out what you want, and that's fine. That takes a little longer, but you should have all of these documents in place. They're important documents. Healthcare proxy is another topic, and but you may want someone to make medical decisions for you. And that only happens if someone is authorized to do so, except under certain circumstances. There's something called the Family Healthcare Decision-Making Act that allows certain people to make medical decisions for you, but only in certain situations.
And this one just popped up. That's our last one. How can you find out who is the executor to a will?
Okay. So wills must be recorded. An estate, when an estate is being probated, will has to be filed with the court. And there is a record room in every courthouse, and you can go up to the record room. You make now, you know, pandemic time, you have to make an appointment, but the will is open and available to be seen by anyone who can put in the name of the decedent and around the date of death. Part of the nice part about a trust is that a trust does not get put into the record room. And so no one can see that. A lot of celebrities choose trust because they don't want people to know what their assets are.
And that brings to a close our questions. Thank you, Jakadi.
Yes. Okay. Thank you, Emily, so much for joining us tonight and presenting on such an important, crucial topic that everyone should be thinking about. Wills are so important because it allows you to select the persons who will receive your assets when you pass away. And I'm so glad Emily is here tonight and she was able to discuss every aspect of estate planning. We greatly appreciate her time tonight.
Jacardi, if anyone has a question, I'll give you my office number and I'm happy to answer. I'm sorry, I didn't mean to interrupt you, but my office number is 212-661-5858. And I'm happy to answer quick questions.
So again, that number was 212-661-5858.
Correct.
Okay.
I just
Yes.
posted that.
Yes. So thank you, Emily, again. And thank you to our attendees for joining us tonight and sticking around with us and asking questions. Thank you to Daniel, our interpreter. And thank you to Robert for, operating our Zooms and making sure they run smoothly and effectively. And so now can everyone just fill out this quick poll so we could just know how tonight's webinar went for you guys?
Yep, do try to answer those questions real quickly that popped up on your screen. We always appreciate that.
And I don't think you need me anymore.
No, you can go. But
Okay.
thank you so much.
Thank
again.
you. Thank you.
Thank you, everyone.
Wonderful presentation.